The to foreign private entities, which authorizes them to use, store, transfer, collect. NEET 22 minutes, page number 139 of mine.
22.
May I read minutes? To argue the matter sometime, Prashant Kusin, the learned senior counsel, appearing along with the counsel on record, placed for withdrawal of the petition, with liberty to avail appropriate legal remedies, including approaching the honorable.
No, but you withdrew the petition. You withdrew the petition.
Well, it was suggested by the Honorable Chief Justice that this matter has to be addressed before the Honorable Apex Court.
But you withdrew the petition. How can we, they have not granted you, you made a statement that, well, I'll withdraw the petition and I'll either file another petition or move this, or move the High Court with liberty to avail appropriate legal remedies, including approaching the Honorable Apex Court.
Yes. But it was suggested by the Honorable Chief Justice that since already this matter had been heard in detail in Justice Puttaswamy case, the Chief Justice suggested that this issue also be considered by the Honorable Apex Court.
Is that you can get your petition restored before the High Court.
Yes.
Right, and pursue your proceedings before the High Court. If they feel that they can't entertain it, at least pass an order on merits.
Yes.
Then you can challenge the order on merits.
Yes. And
so, the learned counsel appearing on behalf of the petitioner has fairly drawn attention to the order dated 20 October 2022, passed by a division bench of the High Court of Karnataka in the petition number 17664 of 2021. Good stuff. Reading the order, it emerges that the counsel for the petitioner had, after arguing the petition, sought the withdrawal of the petition with liberty to avail of appropriate legal remedies, including approaching this court, that is the Supreme Court, bracket. The division bench granted liberty for withdrawal with liberty as sought. Good stuff. There is really no occasion for the High Court to grant liberty to the petitioner to move the Supreme Court. Good stuff. In this view of the matter, learned counsel for the petitioner states that the petitioner may move the High Court for restoration of the petition under Article 226 of the Constitution. Good stop. We do not express any view on the course of action which is sought to be followed, apart from recording what is being submitted. The petitioner under Article 32 does not need to be entertained at this stage, since the petitioner has proposed to pursue the alternate remedy. Petitions accordingly disposed.
All the contentions may be kept open.
Yes.
One small submission.
Yes,
the delay of refiling
already late. Ma'am, what kind of a PI to exclude national and state political parties from participating in municipal and panchayat level elections? How can these kind of PIs be filed?
My lords, it's a pan-India issue. That's why we have filed the PIA.
My bad. Yes. What you say may have substance on the ground, but everything that is true on the ground, I mean, where is the legal right? How can we will be creating legislation if we were to allow your petition to bar political parties and contesting the local body elections
Your Lordship, this
or
state
setting up candidates.
have the role in framing the guidelines to change the ground level scenarios.
It's not something we can assume to ourselves. This is a much broader issue of
This honorable court can issue the guidelines to frame.
how can we do that? I don't think we can. We can withdraw it and pursue whatever other remedies that you want.
Kindly direct to the decide by representation.
Representation for changing the law or imposing a bar. What representation? Representation is all right if you are, there's something personal to you that you want the representation to be disposed of. Your service benefits are not provided.
And kindly allow me to withdraw.
Fine. So why have you come under Article 32? You are saying our judgment in food, my judgment in Food Corporation of India is not being followed. That is stop people who have invalid caste certificates from getting benefit. But we can't have a general PIL like this.
Issue is about when the similar issue decided by the Honorable High Court. The reasoning given by the High Court is very
But
important.
the danger, look at it this way. Suppose 200 people in Maharashtra have been given the benefit of protection of their services, notwithstanding that their caste certificates were invalid. We can't just, those people are not parties. We don't know how many people are there.
Issue is not about the Lordship. This is not a personal issue against any individual. This is about the state of Maharashtra government resolution. If the judgment passed by this Honorable Court, whether this Honorable government of
Are extraordinarily vague and general. Why don't you move the High Court? Because I'll tell you why. You may also have to implead. If there are, say, specific people, or if you're challenging a geo, you may have to challenge that geo. You have not challenged the geo.
that's what I'm pointing out. Just Lordship, kindly see the page number 123. While deciding the similar issue, what contention decided by the Honorable High Court? Kindly see the page 123. The reasoning given by the High Court of petition.
In some other case.
No, same case. Yes, the issue is about the those persons who failed to approve their caste certificate. They approached to the High Court, and while deciding the same issue, just see the reasoning.
Just 1 second.
Page 123.
What an issue will that be? Wishing all the members of the bar a very good term. We have one judgment which I'll just pronounce. And one second. I'll deliver the judgment and I'll hear you afterwards. We're just delivering a judgment. The certification of the film in question is not an issue before us. In that regard, as the High Court has noted, the appellant has not contested Sony Pictures' reply to the legal notice. The course of the hearing, it was stated across the bar that since the film has been released in the meantime, the certification itself is not seriously challenged. The appellant has sought the framing of guidelines and inclusion of recommendations for creators to follow while dealing with sensitive subjects such as the rights of persons with disabilities in the visual media. We have a section called Stereotyping as an Antithesis to Dignity and Non-Discrimination. This court is cognizant of the impact of stereotypes on discrimination and the enjoyment of fundamental rights. We have traced safeguards against stereotyping to the Anti-Discrimination Code under Article 15, the right to dignity and the right to equality. Recent rulings reflect the judiciary's evolving role in not only safeguarding individual rights, but also in addressing complex intersections of disability, gender, and mental health, enriching the discourse on equality. This perspective rejects a one-size-fits-all approach, acknowledging that disability is a nuanced, individualized concept shaped by factors such as mental impairment and personal circumstances. The legal framework stresses the need to prevent stigmatization and discrimination against individuals with disabilities, recognizing the profound impact on their sense of identity and dignity. In the context of historically oppressive representation of persons with disabilities, speech that entrenches stereotypes is opposed to the dignity of such individuals. However, not all speech that uses stereotypes commonly employed against persons with disabilities is abhorrent by reason of such use alone. As stated in the preceding section, the context, the intention, and the overall message must be considered for such use. Companions. This is primarily because of the historical use of humor to mock disability, make jokes at the expense of persons with disabilities, and to use them for comic relief. Also, the medical model treats disability as a personal tragedy, which is by definition incompatible with humor. This understanding is now obsolete under the social model, which views disability as a function of social barriers that disable such individuals. The social model says that stereotypes stem from a lack of familiarity with disability. This lack arises due to inadequate representation and participation of persons with disabilities in dominant discourse. Despite the history and the obsolescence of the medical model, humor is not universally denounced in the context of disability. We must therefore distinguish disabling humor that demeans and disparages persons with disability from disability humor, which challenges conventional wisdom about disability. While disability humor attempts to better understand and explain disability, disabling humor denigrates it. The two cannot be equated in their impact on dignity and on stereotypes about persons with disabilities. Since the issue involves the fundamental rights of persons with disabilities, we take this opportunity to provide a framework of persons with disabilities in the visual media that aligns with the anti-discrimination and dignity-affirming objectives of the Constitution, as well as the Rights of Persons with Disabilities Act. We are cognizant that Article 19.2 is exhaustive of the limitations that can be applied in the freedom guaranteed under Article 19.1a. The framework we wish to lay down is in line with our findings in Vikash Kumar, where we emphasize that the fundamental rights under Part 3 of the Constitution apply with equal rigor to persons with disabilities. The language of our discourse ought to be inclusive rather than alienating. We noted in Vikash Kumar that insensitive language was contrary to the dignity of persons with disabilities. As long as the overall message of the film justifies the depiction of disparaging language being used against persons with disabilities, it cannot be subjected to restrictions beyond those placed in Article 19.2. However, language that disparages persons with disabilities marginalizes them further and supplements the disabling barriers in their social participation without the redeeming quality of the overall message of such portrayal and must be approached with caution. Such representation is problematic not because it offends subjective feelings, but rather because it impairs the objective societal treatment of the affected groups by society. We believe that representation of persons with disabilities must regard the objective social context of their representation and not marginalize persons with disability. And we have now laid down some guidelines, which I'll just read out a few and then can. One, words cultivate institutional discrimination. Terms such as cripple and spastic have come to acquire devalued meanings in societal perceptions about persons with disabilities. They contribute to the negative self-image and perpetuate discriminatory attitudes and practices in society. Two, language that individualizes the impairment and overlooks the disabling social barriers, for example, terms such as afflicted, suffering, and victim, should be avoided or adequately flagged as contrary to the social model. 3. Creators must check for accurate representation of a medical condition as much as possible. The misleading portrayal of what a condition such as night blindness entails may perpetuate misinformation about the condition and entrench stereotypes about persons with such impairments, aggravating the disability. Visual media should strive to depict the diverse realities of persons with disabilities, showcasing not only their challenges but also their successes, talents, and contributions to society. 6. They should neither be lampooned based on myths. People bump into objects in their path, nor presented as super cripples on the other extreme. This stereotype implies that persons with disabilities have extraordinary heroic abilities that merit their dignified treatment. For instance, the notion that visually impaired persons have enhanced spatial senses may not apply to everyone uniformly. It also implies that those who do not have such enhanced for the visual impairment are somehow less than or ideal. 7. Decision-making bodies must bear in mind the values of participation. The nothing about us, without us principle is based on the promotion of participation of persons with disabilities and equalization of opportunities. It must be put to practice in constituting statutory committees and inviting expert opinions for assessing the overall message of films and their impact on dignity of individuals under the Cinematograph Act and rules. The Convention on the Persons on the Rights of Persons with Disability, the Convention on the Protection of Rights of Persons with Disabilities, also requires consultation with and involvement of persons with disabilities in the implementation of measures to encourage portrayal that is consistent with it. Collaboration with disability advocacy groups can provide invaluable insights and guidance on respectful and accurate portrayals, ensuring that content aligns with the lived experiences of persons with disabilities. And then we have referred to training and sensitization programs. So we've laid down a comprehensive framework of hopefully what a portrayal in the visual and electronic media should be like, without intention on the right under Article 19(1). Thank you very much for your assistance, everyone.
It's a path-breaking judgment. You are the petitioner. I am privileged to be a part of this judgment.
You also made your submissions at course of the hearing. Thank you very much.
Thank you so much for this. Thank you.
Much of this, Lord. Can I crave my Lord's indulgence on this?
Yeah, yes.
Manish Sisodia's matter, he's been there in 16 months in jail. The court said trial must be near conclusion. It hadn't started. I filed the SLP. They gave liberty after third. The Supreme Court gave liberty to list it.
On Saturday, so the defects will be cured.
It's a revival because the court said you just keep it in abeyance, revive it. The Lordship has kindly looked into it.
We are looking to it.
You've given the email.
No
Second matter, I'm not troubling Lordship, is showing 23rd. The second matter, 23rd is showing just now. So we'll just say not to delete. There's one more.
Just see what it is. Have you sent an email?
Yes, yes, we see.
I'll attend to it the moment we write.
It's already showing 23rd in the second matter. So it's just not deleting.
If an email is sent, then I say not to be deleted. I even have a code. I call it NTD, not to be deleted. So we'll do that in the afternoon.
I have a question because we have circulated emails. Now, this is a matter of some urgency. Your Lordships have issued notice. There's an interlocutory order. The matter is now for final disposal, my main appeal. But there's a need for urgent further interlocutory relief because I've been outflanked. I don't want to take
I'll make sure that I'll.
Could it come up on Monday, Manoj, next Monday?
I'll immediately attend to it.
I'm very brave.
Yes, not in a matter, my Lord, where I had this urgency, I had moved, my Lord, the vacation to. My Lord, the Lordship said that I have to move the learned Chief Justice first, which I have done. I sent him, my Lord, I made a mentioning memo. No, my Lord, apparently, what are the three?
I think all requests by Saturday evening. If there's something which has remained, I'll do it today itself.
It's just that, my Lord, that we moved the registrar said the orders of the Chief Justice are required. It's now listed on 12th is the day, my Lord. All that we pray for is that it should not be deleted.
I'll look at it.
It cannot be deleted, my lord. That's all.
Let me just see what it is. I'll process it the moment we rise.
There's a 30 petition filed by 6 students from Gujarat. We are praying that the NEET exam should not be cancelled. The lead matter is coming up at item 31 today.
That's all I just mentioned when the matter is clear.
Very well.
Yes.
Lord, a TV channel in Bangalore has been restrained from broadcast completely last Wednesday. We have filed SLT to the registrar this morning, but it could not be mentioned earlier.
Just circulate an email.
Tomorrow, day
Just circulate an email. It'll be listed, but just when? What was the email packet? So then why do you not have to mention?
this morning,
I'll pursue it in the afternoon.
Wednesday,
Don't worry. It'll be attended to today.
after minute.
It'll be attended to right away. Yes, Mr.
One lady petitioner, she is a widow. If Madras High Court granted bail, there was certain conditions below the cheat fund. Her husband committed suicide because
Circulate, Mr. Mishra. Circulate an email. I'll do it.
Lord, they are going to take custody. Lord,
Send an email. The moment I rise at 1 o'clock, I'll attend to it.
that Lord Listing Registrar has allowed it in the morning today.
All right. Just point it out to me. We'll immediately I'll attend to it.
My lord, my case was in the advance list tomorrow, but not in the main. My lord, my case
This
was.
matter pertained to Justice Bopanna's roster.
Yes, my lord.
The registrar informs me I've already reallocated it to another judge. Now that Justice Bopanna has retired, it will come up next week. It's coming up next week.
Lordship, similarly, this is the case, again, in the advance list, this is with respect to the rights of people with wheelchair, the SOP at airports, that learned SG has said he's ready to cooperate. It's just been coming but not listing. ever since.
Just circulate an email. I'll immediately list.
Thank you so much.
Yes.
Hey, I'm giving you a 5 minutes loss. You have finished. For planting that tree loss. This is going, this is going.
No, you can't mention for planting a tree in the Chief Justice Court. You have to then tell. All right. All right. Before we begin, just a couple of housekeeping announcements for the members of the bar. The space in front of courtroom numbers 1, 2, 3, Chief Justice Court 2, 3, 4, and 5 is being completely air conditioned for the convenience of the members of the bar and the litigants. We've been in touch with some of the most leading agencies in the country who are specialized in that because it's a heritage building. Delhi Urban Arts Commission, the IIT, we have gone to IIT Delhi to ensure that the design is secure, safe. Work is going on. I'd expected that it will be completed by the end of the vacation. It's taking a little longer, maybe a few more, maybe a week or so. There'll be a little inconvenience to the members of the bar. So I request you to please excuse us for the inconvenience and bear with it for about a week or so. We'll be completely air conditioning that so that you don't have to go out of the court and walk into the heat there. So that corner is being second. So I request all of you to bear with the inconvenience for a little while. The second, there were 2 waiting rooms just next to the grand staircase, which was set up during COVID. I thought that they were really just makeshift. And lawyers were using them in very large numbers. So during the vacation, those courtrooms, those 2 waiting rooms have been completely restored. They have been made in a manner which would match with the facade of the Supreme Court. So you can all start using it again and wait for your matters in comfort over there in those 2 rooms. The third, we have now expanded facility for the registrar's court. And there will be a full-time registrar who will be working in that court right from Monday to Friday during court hours instead of having rotations and sporadic assignments for registrars to be in that court. So there'll be a full-time registrar's court. Before we begin, share with all the members of the bar. We're very honored to have in our midst Justice Antonio Herman Benjamin, a very distinguished scholar and international judge from Brazil. He's due to be sworn in as the Chief Justice on the 22nd of August this year. We're very privileged to have Justice Antonio with us. He's a great friend of India, one of the foremost international experts in the law relating to the environment. So he's just come back from a trip to Srinagar, Sonmarg, Kargil, Leh, and back. So he drove all the way. He was very fond of India, and we're just sharing with the colleagues what his experiences about that trip. So we welcome you in our midst.
On behalf of the bar also, Lord, I welcome the honorable guest to this.
Thank you. So we'll start with our daily board.
Lord, may I just mention, Lord, I have circulated a mail. The reason is, Lord, I mentioned it before vacation. Lordship said it will be listed. It was not listed because it's an old matter. Regarding a PGI admission matter, Lord.
I'll list it, yes.
If you may I mention?
Just circulate an email and I'll attend to it in the afternoon today. Just circulate an email and I'll get your matter listed as quickly as possible. All right, let's see the first state.
My lord, may I mention item 40? My lord, by the time the matter reaches on board, my lord, NTA can be directed to produce the original OMR of the
Anything of this sort, wait for the matter to reach. Yes, item 1.
Please, my lord. In item 1, this is a bail plea. The petitioner is in custody since 10th of February 2022.
In possession, you were alleged to be in possession of 80 kilograms.
I was not found in the location, my lord.
You are not. They say that your identity cards were found in the vehicle.
Who has found the identity card, my lord?
You are not the registered owner of the.
I am not the registered. I have placed it on record, my lord. The registered owner says in his cross-examination, he has been cross-examined.
The allegation is that the vehicle has been transferred in your favor.
He says, but in the cross-examination, he says he cannot confirm if the vehicle that has been alleged to be found by the police is the same vehicle which he sold to me, even otherwise, my lords.
All right, we issue notice here and keep it up to 2 weeks. Serve the standing council for the state of Madhya Pradesh.
I'm most grateful.
Issue notice, returnable on liberty to serve the standing council for the state of Madhya Pradesh. He has been denied. Continue.
I'm most grateful, my lords.
Item 2.
Very short question is what is the
There's a delay of 235 days.
There
But then you never objected before the arbitrator. Now there's an award.
It's a matter of record that we objected only at the stage of 37, my lord. I cannot quarrel with that.
We'll dismiss it. What we'll do is we'll dismiss it on the ground of limitation so that it doesn't become a precedent in any other case.
Question of
law open. There's a delay of 235 days in filing the special petition against the judgment of the Madhya Pradesh High Court dated 9 December 2022. Full stop. There is no satisfactory explanation for the delay. Full stop. Hence, the petition is dismissed on the ground of delay. However, we clarify that since the bar of limitation has intervened, it has not become necessary for this court to express any opinion on the question of law raised.
It will remain open, man.
Which is kept open. We shouldn't say it's open because actually the question of law is decided in your favor by our judgment of 2018. Because the judgment in VA has been overruled by our court.
That is
so if we keep it open, we are tacitly then casting doubt on our judgment. The question of law is in your favor. We are not interfering in this case.
At this stage, if I may only...
The question of law is kept open. Fair enough. You want to be here.
I'm very grateful, man.
Please, my lords. My lords, this petition has become infructuous because subsequent developments have taken...
Counsel appearing on behalf of the petitioner states that the petition has been rendered infructuous by subsequent developments.
I'm sorry, I want the question of the law to remain open, my lords. Simply being, my lords, because this is for the second petition, my lords, pursuant to a settlement agreement. And Lordship's court has...
Always open queas. Nothing is concluded by us. We're just saying that it's infructuous. Item 4.
My lords, it will ultimately, the matter will ultimately be the Lordship's court only. So I'm just...
So it's always open queas. We are saying it's disposed of as infructuous. It can never bind in a future bench.
I'm very grateful, my lords.
This matter, admittedly, the NCLT finds that my claim and my allotment to the flat is reflected in the information memorandum, which is the basis of any resolution plan. And it is showing in the record.
What about delay?
Yes, my lords. On delay, my lords, admittedly, I am not present when this pronouncement is made. My lords, the matter is reserved 3 months back. It comes in a pronouncement, my lords. My appearance is not there. I have vehemently said that I was not present. It is uploaded, my lords, and
What is the date on which it is uploaded?
my lords, it is uploaded on 22nd of August 23, from which, my lords, I am within limitation, excluding the certified.
You were not
copy.
present. Were you a party?
Yes, it was my application, my lords. On my application while reserving.
But then if it's your application,
Yes, ma'am.
then can you say that I was not present? I don't know because.
So, my lords, the arguments happen. The order stands reserved.
But it is,
not
when is the order pronounced actually? It's not pronounced at all.
Not on the dates argued, my lords, not on the dates heard. It comes up in the list 3 months after for pronouncement.
22nd August.
No, my lords, 11th of August. 22nd August is when it is uploaded and which is when I gain knowledge of the order. And I, my lords, file immediately. I file the appeal immediately.
Learned counsel appearing on behalf of the appellant submits that that in the application which was filed by the appellant, though the order was passed by the National Company Law Tribunal on 11 August 2023.
Yes.
The order was uploaded only on 22 August 2023. Hence, it has been urged that the appeal which was filed on the date.
The appeal was
October 2023.
Yes. Well, it's 10th October 23.
10 October 2023 would be within the period of limitation of?
Well, it's 61.
The limitation. Please issue notice.
Great.
Returnable.
Malaj, may I only make one request? The resolution plan basis which my application was dismissed even to date has not been approved by the NCLT. Now, Malaj, may I only request for an interim stay until
make it returnable in 2 weeks.
Wait for
stay everything. Serve Dusty and come.
So,
Item 5.
See, in this case, the NABARD, though initially it said that there may be certain irregularities in the functioning of the bank, subsequently it filed an affidavit before the High Court stating that the resolution of the board was proper and that there were no irregularities. Ultimately, this was a public interest litigation. You brought some grievance to the attention of the court. The court has felt that it is not necessary to interfere.
Case 368 may be seen for a moment.
What is that?
Ordered by High Court, Honorable High Court.
The earlier High Court, the earlier order.
Yes, Lord. It says, Lord, pursuant to previous order, action taken, report on behalf of the NABARD has been placed on record. Prima facie, certain allegations were stated to be true.
But that is prima facie. Subsequently, NABARD filed an affidavit and says that you have now looked at it and there's nothing.
Later, Lord.
Anyway, as a PIL petitioner, your duty was to point it out to the High Court. High Court went into it. NABARD is a National Bank for Rural Development. They filed an affidavit. Now, why should we?
But the error is 389 may be seen, Lord. Uttar Bihar Gramin Bank, as well as not the sponsor bank, Central Bank of India was directed to take decision on this erroneous activity. That is my
ultimately, as a bank, it is regulated by the state authorities, since it's a state bank, as well as to a certain extent by the Reserve Bank of India. Why should we presume that they will not look into the any regulatory failures in the bank?
Any fraud above 3 crores is directed to be investigated by CBI. But here the quantum is not above. More than 500 crores. That is.
So, counsel, we are referring to the affidavit filed by NABARD dated 21st February 2024, where the averment is that it is humbly submitted that as per the specific directions dated 18 January 2024 of this court, the instances pointed out in the special audit report were scrutinized On scrutiny, respondent number 4 is satisfied with the resolution of the board of UBGB that the guidelines of fraud are not applicable to the present matter, audit report, and therefore the matter is not required to be referred to local police/CBI as per clause 9.1 and 9.2 of respondent number 4.
So not less. Initially, not 13.
I think you made our point clear. I think we'll not entertain it further. It is a PI after all. Yes, dismissed. Item 6. Item 6. Yes, Mr. Raghunath, you are on the screen.
Advocate Raghunath on behalf of
Filed a writ petition before the High Court for early hearing of your appeal before the DRAT. And now you are in the Supreme Court under 136. We're not going to entertain these kind of...
Your Honor, my lord, these steps will be against the order of the Honorable High Court, and there is no supervisor. There is no about 24 hearings have happened.
What do we do? The tribunals are, it's not that the tribunals don't have work. They have their own priority.
But my lord, it's a question of recovery of 208 crores rupees.
No, but you are postulating that your case is the most important to be reaching the line or the queue. Other cases may be as important before their tribunal. Why should we expedite your case? We'll not do anything like that. Thank you. Dismissed.
No, this is a petition seeking appointment of an arbitrator. The clause of arbitration which finds place in the SPA was SHA, which was initially disputed by the other side, gradually accepted on an affidavit and recorded by the High Court in its order, saying that they were trying to mislead the court, but they have then accepted the existence of the SHA and the arbitration clause. We are only seeking appointment of an arbitrator because one of the respondents is a Sri Lankan citizen and the other is an Indian citizen, both of them being shareholders in the company, which was created pursuant to the SHA.
Saroj, I'm appearing for the respondents herein. Let them supply me a copy. I'll come back in 2 weeks and give my no objection for the appointment.
For the appointment of the arbitrator?
Yes. After perusing the agreement, because there was a confusion about the agreement per se, the notice of invocation says the arbitrator.
Fair enough. You are appearing for both the respondents, right? You are appearing for both the respondents.
Yes.
Fair enough.
No, they have admitted the existence
I know,
of
he doesn't have a copy of the paper. He's on caveat. So
I'm not on caveat also. I'm just appearing.
Issue notice. Mr. Can I have your name?
Karthik Malhotra.
Mr. Karthik Malhotra, and counsel appearing on behalf of the states that he has instructions to appear on behalf of the respondents, and seeks a short adjournment to take instructions. A copy of the paper book be supplied in the electronic form to the Senate counsel for the respondents. List on. Should we keep it on Monday and finish it on Monday?
Please, my lords.
My lords, Friday.
All right, next Friday.
Next Friday.
Very good. Next.
Yeah, man. Item number 8, my lords. The candidate was selected as the president of the Consumer Disputes Redressal Commission for Mallarkotla,
Sangrur.
For Sangrur. The candidate who was selected resigned.
Within 6 months.
Within 6 months. In which case, you are the second candidate. You have no vested right for appointment. If the candidate does not accept the appointment, then the second candidate can say that, well, appoint me to the post. Once a candidate is appointed, then the select list comes to an end because the process is complete.
Was only this, Lord, that the OM says that if a person joins and resigns or vacates within 1 year, then, my lord, the merit list has to follow. In this case, my lord, the OM is there and the judgment of my lordship, 3 judges of this court have said. And my lords, this is since no, that's right, Lord. But my contention is that since this is a judicial selection, instead of going through a fresh selection process, my lord, people can be, and I'm there in the merit, my lords.
The government picked out all candidates who are lower in the list. That whole selection process in Punjab was replete with all kinds of difficulties.
What I have done is, in my district, Sangrur, after my lord,
because the Punjab government thought that they can just pick up candidates who, are, suitable to them, overlooking the select list.
So that's my case. When one resigned, they appointed someone who was not even in the list, who didn't even apply. I was there at number 2. They didn't call me.
His appointment may be invalid, but he has no vested right.
So he's R5, my lords. He's R5 here. I said so in my LPA. When the writ was pending before the Honorable Single Judge,
whom did they appoint?
they appointed one Jyot Karan, who was not even in the select list.
No,
Page
but
70 is the select list.
But look at it this way. Yes, your plea was appoint you. You're not really concerned about his appointment.
In the writ petition, it was appoint me. When the judgment is reserved in the writ petition, on that day, they appoint this person. I filed an LPA. I said, how can you appoint him? You have to appoint me. The OM is there in my favor. The 3 judges is in my favor.
Did you ever challenge his appointment?
In the LPA. Because in the writ petition, he was not appointed. He was appointed on the day when the judgment in the writ petition was reserved. So I could not have made him a party in the writ petition. I made him immediately in the LPA. I made him immediately in the LPA. I made an application, and he's R5 here before your lordships. A person who is not selected is working well out as a presiding officer of the Consumer Forum, and I was there in the merit list. As a wait panel. OM says, my lords, the
petitioner, the grievance of the petitioner is that the candidate who was first in the select list, right?
Very well.
The candidate who was first in the select list for appointment to the post of president of the Consumer Disputes Redressal Commission, Sangrur, resigned. Full stop. Thereafter, full stop. The petitioner was second in the select list. Full stop. According to the Learned Counsel, after the judgment is reserved by the single judge,
yes,
and before it was delivered,
yes,
the 5th respondent was appointed as the president of the District Consumer Disputes Redressal Forum, though he was lower.
He was not in
though he was not in the merit list at all. Full stop. The petitioner has been non-suited on the ground that once the first candidate, was it a fresh appointment then? They just picked him up without him. All right, we have recorded your submission. The grievance of the petitioner, therefore, is that even if he was not eligible to be appointed as district, the grievance of the petitioner is that the selection of the 5th respondent is completely contrary to law, since his name did not figure in the merit list at all. Full stop. Issue notice, returnable on after 2 weeks. Thusly permitted in addition. Liberty to serve the standing counsel for the state of Punjab in addition. Well, I'm here after 280 days delay with implement.
Other passed away during this period. Otherwise,
20 days.
20 days.
And on interest, claims on interest in addition to the return of funds.
I invite your lordship's kind attention back page 19 only. Page 19, just it has been recognized.
What's the point?
Approved. Yes.
What's the point that you want to
make? It has been approved. It has been said that yes, this due is there.
You have to open the door. You have to first get the delay condoned.
My father passed away. I have said so. And he was bedridden, and
there's a delay of 280 days in filing the special petition, for which there's no satisfactory explanation. The petition is dismissed on the ground of limitation.
I circulated a note yesterday evening.
Yes.
My point is that it's a statutory violation and be under remedy.
Tell us one thing. After the conciliation proceedings failed before the Facilitation Council, you have said that they never called upon you to file a statement of claim.
No statement of, I was a defendant, so no statement of claim is filed, no evidence, nothing. Just that the initial claim form which is filed before the MSME, which is an unrecent, just 1 page of form. On that basis, only the ultimate order is passed.
You get to file your statement of defense.
We did get to file. We got to file. But the conciliation, how it failed was that the first day I show up without the wakalatnama. That day itself, the other side prefers an application, already pre-drafted application. And on that basis of the application, same day, immediately the order is passed, there's no conciliation possible, let's move. But Section 65 of the Arbitration Conciliation Act says, mandatorily, both sides have to be called upon to file the written responses, and that conciliation has to happen in good faith. Even UK law and all, they have gone into that level where they say
that conciliation failed, Thereafter, what happened before the
No conciliation happened. Then I was called upon to file my defense. I filed. Then arguments reserved. Some fellow, one Mr. RK, heard the arguments. The ultimate award is passed by some other 3 people who have not even heard the matters. So RK is the signatures on the
you come here against which order?
Because I've come again the order passed by the division bench of the High Court saying my 34 is not maintainable. 34 I should have gone in 34. Writ petition is not maintainable.
But you have a remedy under 34, right?
Because I won't have a remedy under 34 because Section 65 violations of the Arbitration Conciliation Act are not palatable under 34 grounds.
No, but what you are aggrieved by finally is the award.
Because I've tried to draw a distinction from that India Glycos judgment, which is falling from my lord. I'm conscious of that. There's a Jharkhand Urja judgment in my favor, which says if the mandatory statutory violations have taken place, then writ petition is maintainable vis-a-vis the MSME Act. Squarely covers my case. Number 2, my lords, the India Glycos judgment and other judgments which my lords have held, those are cases where people are trying to make their cases on merits of the case. I am not on merits at all. I am on the violations of the MSME Act. And I am trying to portray my case there, my lords. So my humble submission is basic structure 226, etc. will be attracted when statutory violations have taken place. If it was a case on in fact, it's
Problem is that you are yourself saying that you're not challenging it on merits, but only on statutory violations.
because the merits grounds are also there. I'm saying for the statutory
merits which you raised was that they were not registered as a micro MSME on the date of the agreement.
No.
So there's a finding of fact concurrently that they were registered.
No, what has happened is those merits arguments are also there, but to distinguish my case from the previous judgments, that's why I'm trying to portray my cases there.
Sold, supplied, and delivered. You have not paid them.
No, that's not the case at all. My statement of defense is not on record. My apologies on that. But what is the transaction is slightly different.
Balance of the principal amount of 24.82 lakhs is not paid.
Because I'm ready to deposit the principal amount. That's no difficulty at all. But the point is, my defense could not be brought on record because there's no procedure that has happened. There's no basic arbitration and conciliation norms that have been followed. In fact, there's one Delhi High Court judgment which says if it shocks the conscience of the judge, then the petition is maintainable, even against MSME matters.
In a petition under Section 34, all these grounds, suppose in an arbitration, forget the MSME Act, arbitrator doesn't hear the defendant and passes an award. Is that not amenable to a 34 application?
I brought on, my lords, the mandatory provisions of Arbitration Act not followed, ground under 34, absolutely correct, my lords. But my lords, this is under the conciliation process of Section 65 violations. So they may not be followed under the 34, my lords. And besides, my lord, one person hearing the matter, other person passing the award, who I don't even know.
Why did you not choose to challenge the award under Section 34? All these grounds are available. That's your ground is a violation of public policy.
I'm only saying, my lords, that under the Jharkhand Urja matter, I'm squarely covered, my lords.
Thereafter, it becomes an executable decree, right?
May I say this, my lords?
For the writ is that you don't have to deposit.
May I say this, my lords? The Jharkhand Urja judgment which covers me is of 2021. My lord's judgment is of 2023.
Leave it open to pursue your remedies under Section 34.
I'm so grateful, my lords.
The petitioner had an efficacious remedy of challenging the award of the Facilitation Council under the MSME Act by taking recourse to the provisions of Section 34(2) of the Arbitration and Conciliation Act 1996. This was the matter, the High Court was justified in declining to entertain the writ petition under Article 226 of the Constitution. Hence, we are of the considered view that the grievances which are sought to be raised in these proceedings can be addressed in a petition under Section 34. Full stop. Any observations by the High Court on the merits in the impugned order shall not stand in the way of the petitioner taking recourse to the remedies to challenge the arbitral award.
I'll be hit by delay, my lords, because now
can say you were bona fide pursuing your remedies before the High Court. What else can we say?
Malas,
You can't condone the delay, which is beyond now the 90 days.
Malas, that's there, Malas, but that will be ready to be, Malas. It's a good case on merits, Malas. Malas have seen what has happened in this case, Malas. In fact, Malas.
You have vested right in yours to their benefit. How can we obviate a limit set by Parliament?
Malas, I understand that,
Well,
Malas.
really speaking, if it's barred by limitation, you should just dismiss it. Otherwise, your client will spend another round of.
But my loss, give me liberty, my loss will not fructify to my interest if the debt delay aspect is not covered.
All right. But we'll not condone the delay here.
My loss may only observe that I mean permitted to erase this point. That will be my loss.
You can always say that condone the, but we can't because there's a maximum period which can be which is condonable. We can't go beyond that, like the IBC, the Arbitration Act. Condone the delay of 36 days in filing the SLP. There's no difficulty. Then you can say I was pursuing my remedies bona fide before the Supreme Court.
I'm in bylaws hands for us.
You can do it.
Item 11.
Question sets aside, my lord, the well-reasoned decree and the judgment of the trial court. Para 15, my lord, it proceeds to record a wrong date, contrary to what has been pleaded by the plaintiff himself. And then my lord says that we were at fault in not pinpointing it promptly. My lord, three things were missing from the impugned judgment. If your lordship may please see, my lord, please.
You paid them 90% of the payment.
That's right.
Right. So the dispute was only in regard to the balance 10%.
Lordship, please.
So the High Court says first, the very fact that you paid 90% shows that the work was being executed. Now, question is still, I mean, you may still have a point that, there were delays or deficiencies on the part of the respondent. Where did you raise the issue of delays or deficiencies?
No, no. We have said so in the written statement, coupled with the fact, my lord, there is a finding of fact that the work completed was only to the extent of 90%. And therefore, my lord, the learned trial court held this. Lord, please have a look at page 175.
So what evidence did you produce to establish that there were delays?
Yes, sir. 30th of next year, P11, your lordships may see. Or my lord, lordships may please have a next year P12. Now, this letter, which we have pointed out, my lord, on 30th November 2012, the judgment in question says that
but tell us what are the evidence which you laid.
Lord, this was one of the letters, Lord, 30th November, and the rejection letters at document P11. Kindly just see, Lord, the next year P11 from pages 102.
You had to prove your defense that there were delays and that there were delays or deficiencies by adducing the evidence of a person cognizant of the contract which was being performed, and then establish, by producing documentary material that, there was a shortage of work or there was measurement carried out which resulted in,
If I may say so with respect, my lord, the next year P11 pages 102 to 115 were the rejection notes. Then, my lord, the chairman of the company appeared as DW1. And then, my lord, 30th November 2012 letter, which was within the warranty period, but not considered by the judgment in question. That has been set aside, my lord, on the premise that the work was completed in July 2011. But the plaintiff himself says that it was in 2012. Para 19, if I may just draw your lordship's kind attention, please have a look, my lord, at para 19, page 187. That is, my lord, the fundamental error, my lord, in the judgment. Besides the point, my lord, that para 19,
ultimately, you are here under 136.
I know, Lord.
But
Lord, only two respectful submissions. First and the foremost, my lord, the evidence, etc., my lord, even the bills which were presented. The learned trial court has held that these were not actually the bills which were submitted or ought to have been submitted. They have not been proved. Then, my lord, there is a heavy discrepancy on my pointing out the deficiencies because the High Court says, my lord,
it's purely a matter of appreciation of evidence in our case. So thank you.
Yes. Right.
This has to be tagged. This has to be tagged. Ganpati deal. This has to be tagged.
But it's kindly see the tribunal's order for a minute. It's PDF.
You are appearing for?
Well, I'm on KV. I don't know.
We've got other matters which are pending, so we'll.
Well, kindly see, because ultimately the tribunal, I had gone in appeal. The tribunal has decided this issue only on Ganpati reform, not on merits. and with the liberty given that if review is allowed by the Supreme Court, please come back.
Therefore, we'll tag it. We'll tag
The
it.
request is because ultimately, even my lords lag it.
Got other matters pending.
I'm not saying no. It's not that they are remediless. Tribunal says if the review is allowed, please come back to us. That's liberty.
We'll keep it here.
On marriage, ultimately,
We don't want to follow a different course of action because this will affect other matters which are pending. So we should notice and chat.
Dismiss the numerous matters.
We'll keep it. We'll keep it here. Yes.
Well, ultimately, because the law will be sending back to the tribunal.
All right. Very good.
My lord, I'm only praying for a Passover, my lord.
Tell us what the matter is about. You argue.
My lord, the learned solicitor general is leading us, my lord.
So for us, you are the solicitor general at this moment. Tell us what the matter is about.
My lord.
The matter is about.
Argue for 5 minutes, then we'll look into.
Mr. Solicitor, just one second. Let a junior argue the matter. Please sit by side. Yes. Tell us what the matter is about.
My lord, the matter is about non-filing of affidavit of admission denial along with the written statement, my lord.
So the High Court has relied on the Delhi High Court rules,
my lord,
according to which the list of documents has to be filed at a much anterior stage. It says affidavit of without an affidavit of admission and denial, right? So the written statement itself will not be taken on the record without an affidavit of admission and denial.
My lord,
that's the Delhi High Court rule.
That's the Delhi High Court.
That's why you have been non-suited. Now, what is your answer to that?
My lord, CPC Order 11, Rule 4, my lords.
Yes.
It is very clear, my lords. The affidavit of admission denial has to be filed after interrogation and investigation of the documents have been done, my lords.
And what does the Commercial Courts Act say?
Commercial Court Act, my lords. This is the Order 11, Rule 4 as amended by the Commercial Court Act, my lords.
Right, but which is the provision of the Commercial Courts Act?
My lord, the Commercial Court Act amends CPC.
Which is the provision of the Commercial Courts Act which you are relying upon?
Page 15, my lords, of the impugned order.
Solicitor said 15, so you said 50. Okay, the issue notice. Oh, right. Issue notice. You have heard Mr. What's your name?
Avinash Agarwal.
You have heard Mr. Tushar Mehta and Solicitor General with Mr. Avinash Agarwal. Issue notice. Tenable on. Till so and so for the proceedings. Should we stay in the proceedings? For the proceedings in the
Your question would be, the High Court says
the rules will prevail over the Act, over the CPC.
There are 22.
Returnable on so and so. Pending till the next date of listing, there shall be a stay of further proceedings in the suit. So, what happened was right. $123 days will issue notice on
the advocate underwent some ISIS. Item 14.
Lord, I beg to appear on behalf of the petitioner. My lord, firstly, my lord,
the issue is as to whether after the appointment of the arbitrator by the Calcutta High Court,
yes,
the Tripura Commercial Court could have refused to refer the matter to arbitration. And I think the High Court is
my lord,
without appointed an arbitrator,
without examining and considering the records that were lying before the arbitrator, which is completely a separate set of pleadings, my lord, before the arbitrator. My claim before the commercial court is completely independent of the
all this can be argued before the arbitrator. Why should we entertain it at this
stage? The arbitrator, the Section 11 application on the basis of which the arbitrator has been appointed by the Calcutta High Court, my lord, is based on arbitration agreement.
Overall, the long and short of the story is that it can be sent to the arbitral tribunal. Right?
Well, my set of pleadings in the commercials, it is completely independent of the dealership agreement. I am not at all governed by the dealership agreement. There is a basic misunderstanding on the part of the court, my lord. Secondly, my lord, without considering and examining the records lying before the arbitrator at Calcutta, my lord, the court could not have at paragraph 18, my lord. If your lordship kindly turns to page 15, paragraph 16.
Ultimately, what has the High Court done? The High Court has said that let the commercial remand order and saying that the commercial court should consider this.
Yes. Well, there could be parallel proceedings, but without looking into what was there before the arbitrator, the set of claims that were completely different. And my claim before the is a money suit, while it is a simple money suit, it's a commercial claim. It is not a case of claim and a counterclaim. My set of facts are completely independent of the dealership agreement. Paragraph 10 of the plate, my lord, that is a different set of facts. Secondly, my lord, the High Court had interfered.
Who are you actually? Who are you in the sense? Who is your client?
Well, my client is the instant petitioner, my lord, who has filed the commercial court in the Tripura High Court, in the commercial division court in Tripura.
The dealer?
No. Yes, I am a dealer. I am a dealer, but not eminent.
Maybe you are saying that your claim is independent of the dealership agreement.
Yes.
Your status arises as a dealer under the dealership agreement.
No, that
dealership the High Court says, please consider our order to direct the commercial court to consider their order appointing an arbitrator.
Yes. Well, the arbitration agreement, which is between me and the dealer, maybe, my lord, it's an alleged document, is not at all a document which is with my custody. I have specifically stated in my plaint that I have never seen, this document has never seen the light of the day. In that event of the matter, my set of pleadings in the commercial court could have been in the light of the dealership agreement.
All this has to be looked at by the arbitrator. All this
arbitrator is deciding on the dealership agreement. That is for the respondent. That is the claim of the respondent against me. My claim against the respondent is completely different, and my suit is a prior.
Heard your point. No, it has to be before the arbitral tribunal. But anyway, we are not directing it has to be sent to the arbitral tribunal. The High Court has merely remanded the matter, directing the Tripura Commercial Court to consider its order, Calcutta High Court order appointing an arbitrator. That's all.
But this is where I joined my issue. Just one minute.
I heard you now. I think we've made access clear.
Lordship, in item 15, it is in my humble submission that the Honorable High Court has committed grave error in saying that the minor dispute was one because it was transferred without following the provisions of law, and according to me, it is void.
For that, you have to answer why we should condone the delay of 170 days in filing the SLP.
My Lordship, because the petitioner was not knowing that there is a limitation in filing the SLP in the Supreme Court, and the advocate who was dealing with the matter in High Court
on the ground of delay. Yes, thank you. Item 16.
My Lordship, I kindly consider as soon as we got the matter, we got it filed. My Lordship, kindly consider, because the petitioners are also very not very poor. My Lordship,
they have been in possession of the mine for the last 50 years.
But my Lordship, that transfer was illegal. My Lordship, that was
not a case for injunction. The High Court says that somebody who was in possession of a mine for 50 years, they can't be now injuncted like this. So, if we are dismissing, we can say this. We can even say this. Though there's a delay of 170 days in filing the special petition, we've also examined the correctness of the impugned order on merits and find no reason to interfere with the order. The special petition is accordingly dismissed both on the ground of delay and on merits.
My Lordship, one last.
Item 16.
Issuing any show cause notice and contrary to the terms of the tender itself, is my Royal Lordship said.
The cancellation maybe. Learned Senior Counsel appearing on behalf of the petitioner submits that the petitioner was blacklisted for a period of 3 years from participating in the contracts of the municipal corporation without a notice to show cause being issued. Issue notice confined to the above aspect,
Not
returnable on capital.
Lord, we are only requesting for the same, Lord, because I won't be in a position to participate in any of the options, my Lord.
If we make a short note.
Lordship, be there.
Oh, I see.
Lordship, that's fine.
It's a due process.
Perfect.
Simultaneously, a number of petitions have been disposed of by the High Court. All the matters are not listed today. They for a one time.
But there's a 174 delay, 174 day delay here.
No, as far as the first matter is concerned, there is 74.
That's not 174 day.
This is not there, madam. In other words,
174.
yes, but in other matters, the delay is not too much, madam. In some matters, it's
17. How many matters are there on 17?
In total, there are 8 matters, 7 matters, madam. All the matters are not listed today, madam. It will be taken after a week, madam.
You can get your other matters. We'll dismiss this on the ground of delay.
No, madam,
How can the state keep on the other matters where there is no delay, therefore condone?
I'm not saying, madam. Can you take up all the matters together because there's no delay, what is concerned?
We will keep those other matters. We'll dismiss this on limitation.
Madam, can you take up
limitation applies equally to everybody, and I think state governments in India now must be absolutely alert. And merely because it is a state, the government officers cannot just sit.
I know, as per my
allow
74, my lord.
And it's serial number 37. There's 74 days delay. We'll look at that matter independently. When it reaches, we'll take it up. This one we will dismiss on the ground of limitation.
No, my lord, I'm just saying that because on the technical ground, can you see? Technical ground, they have to more than 3 or 4 crore rupees, can you see? They have to pay more than 3 or 4 crore rupees, can you see?
7 reaches. We'll see what the merits.
All the matters are not listed today. The branch is taken after a week, but all the matters.
How many are there?
In total, there are 8 matters. Only 3 or.
Let's give the number to the numbers.
Yes, I will put the numbers.
List together with so and so.
On Friday, madam. Next Friday. In the meantime, if there is defect, I will put the defect all day.
Item 18.
But it's on Friday, madam.
Next Friday.
This is a really piquant and unjust situation where I can't appoint an arbitrator under litigation. Their appeal has been remanded by this Honorable Court. The High Court, because it was earlier dismissed as non-maintainable. So the arbitration award has been set aside as being perverse at my instance.
And the arbitration award was set aside by the single judge.
Section 34 judge?
Justice Dhanuka's judgment.
That's right.
But we had dealt with this.
Justice Baldota's judgment.
Justice Baldota's judgment. There was a similar case we just came a few days back where there was the division bench set aside Justice Baldota's award on the
ground of perversity.
On the ground. What happened in the single judge?
Thereafter, after the award was set aside on the ground of perversity, they filed a Section 37 application, which was dismissed as non-maintainable. Then they came to this Honorable Court. This Honorable Court found the appeal was maintainable and therefore remanded it back
to the
division bench, and that matter is still pending. Though we have made requests, and this Honorable Court had also directed expedition, that matter is still pending. When therefore this matter is still pending litigation, and the situation is that a perverse award against me has been set aside, behind my back, 2018, they enter into a development agreement with respondent number 3. This is not disclosed. It is disclosed for the first time in 2023, where when I discover by chance that a huge construction is being put up, I move an application.
Mr. Ramchandran, what is the investment by your client?
The investment by my clients is 22 lakhs in a matter of 1.5 crore at that time. The amount should not matter at all. That was the initial payment.
If a construction has taken place, and now you have invested about 22 lakhs,
he has paid 8 lakhs. The respondent number 3 has paid 8 lakhs. It can't go by the figures.
Seems to have also been impressed by the fact that now impeding the development, the tenants on the property who are waiting for being rehabilitated.
With respect, those tenants who are part of the original bungalow, it's not some resettlement scheme. It is a bungalow which is being demolished and a 15-story structure is being put up.
The award against you in the arbitration, right? The award in the arbitration. What is the actual award in the arbitration which was set aside?
The award was that I'm not entitled to specific performance and I'm not entitled to damages, both of which have been set aside because the award has been held to be perverse. So the matter is at large, and I file a fresh Section 11 application for the reason now that this third party has come. This third party seeks to get impleaded in that appeal. And I can't appoint a Section 11. Award was that my claim was dismissed. My claim was against his reneging on the 2005
So your claim
MOU.
for essentially for specific performance or implementation of the MOU, that was rejected by the arbitrator. The single judge set aside the award and just set aside the award simpliciter.
Simply of perversity, but set it aside.
Right.
Therefore, fresh arbitration has to start. In any case, a fresh arbitration has to start. Immediately after the appeal was dismissed by the Bombay High Court, I filed a Section 11 application for fresh appointment of an arbitrator.
The appeal is by the other side, of course.
The appeal by the other side. When that appeal was dismissed, I filed a Section 11 application. But then this honorable court remanded the matter back to the High Court. So logically,
even assuming that ultimately in the appeal, the award is affirmed, you still have recourse to a fresh Section 11.
And that is not being allowed by the impugned judgment. That is what is not being allowed.
They have created third-party rights in the meantime.
Lordships, and they have created third-party rights. And when a fault is being found with me.
We'll have to consider this because you have been non-suited even on your
Lordship, please.
Section 9 or something, we may or may not be with you.
Section 9 minutes, my request is this. If behind my back, this agreement is entered into, and not disclosed to the court,
You're also a very big builder in Mumbai. There's nothing behind your back. You see the whole construction coming up, and you just said a big building is.
I happened to see it because I was passing that way. I'm not traveling on all the roads of Bombay every day. I'm not traveling on all the roads of Bombay.
This cannot buy. This
on Section 9, if your lordships are issuing notice.
11, perhaps you have a point that at least your remedy under 11 can be kept open. Depending upon the outcome of that appeal. Perhaps we'll see.
On Section 9, my only limited prayer is this, as your lordships issue notice, let them not create third-party rights in favor of buyers. Let them not...
we are issuing notice. We'll make a short notice. We don't want to issue an interim order without hearing them. Serve Dusty and come. We'll just rise. Members of the bar will rise because our distinguished colleagues from Brazil has to go around the court in next... look at the facility. We just rise for 2 minutes. And
before the learned visitor rises with your lordships, I thought an anecdote, seeing your lordships encouraging a junior a few matters back. 48 years ago, in court number 2, Senior Justice Chandrachud was the presiding judge, and a 2-month-old lawyer, namely yours truly, was appearing before him, shaking with nervousness. And Senior Justice Chandrachud looked at the appearance slip and said, "Yes, Mr. Ramachandran," which gave me such confidence that I was able to argue a useless matter for 5 or 10 minutes. So I was reminded of that day, my lord. Sorry, your lordship.
Thank you, Mr. Ramsey.
But can I request, my lord, for Dusty in addition, my lord, so that it comes in 2 weeks, my
We
lord?
just told the court master it will be served dusty and after 2 weeks.
And no third party rights, my lord, in the meantime.
That's why we're giving you 2 weeks. Thank you.
Lordship, please.